Good afternoon, everyone, and welcome to the first webinar in our series, Balancing Biodiversity Conservation with Development Pressure in Urban Landscapes. My name's Mike Badry. I'm the Director of the Conservation Science section with the Ministry of Water, Land, and Resource Stewardship. And I am joining you today from the unceded ancestral and traditional territory of the Lekwungen-speaking people, including the Songhees, Esquimalt, and Wasanich First Nations. And I am here in Victoria. And I invite you all to reflect on the area that you live and work in as well. So I'm very excited to have you join us today. As I said, this is the first in a comprehensive webinar series that we're going to be running every Tuesday from today until March 18th, 2025. And it's a collaboration between the Ministry of Water, Land, and Resource Stewardship and the Thompson-Nicola Conservation Collaborative. It's designed to explore the complex challenges of balancing rapid development with the vital need to conserve our biodiversity. And as housing demands continue to rise, municipalities and regional districts are facing increasing pressure to accommodate growth while simultaneously protecting our natural environment. This series will delve into existing case studies, essential information sources, and practical published tools to help planners and environmental professionals and others navigate these critical issues. So over the course of this series, we'll cover several key topics, including regulatory frameworks and policy, provincial best practices and mitigation guidelines and planning tools. Each of the webinars will be recorded and posted to the webinar webpage on TNCC's website. Today's webinar will focus specifically on biodiversity and local government actions, Green Bylaws Post Bill 44, and will be presented by Deborah Curran. And just before we begin with the presentation, I'd like to cover a few housekeeping items regarding our Zoom webinar platform. We'll have a dedicated Q&A session at the end of the presentation to address your questions. So please submit your questions using that Q&A feature that's at the bottom of your Zoom screen. And please click the thumbs up icon to upvote a question to ensure the most relevant and interesting questions will be addressed live during that Q&A session. The chat function is also available for comments and networking. It's also at the bottom of the Zoom screen. So please note that any questions, though, submitted in the chat may not be addressed during the Q&A session. So make sure you get those questions into that function, the Q&A function. And if you experience any technical difficulties, please try refreshing your browser or checking your internet connection. And if the problem persists, please use the chat function to alert Allie. She is going to be giving us the tech support today. She's with the Thompson-Nicola Conservation Collaborative, and she'll do her best to assist you. As I said, we're recording this webinar, and the recording will be shared within 1 week of this presentation. And at the end of the webinar, we'll have a short survey, and we greatly value any feedback as it helps us improve future events. So I thank you for that. So just before we dive into this main presentation, we'd like to get a sense of where everyone's going to be joining us from today. We're using a fun interactive tool called Poll Everywhere. And on your screen, we should see a map of British Columbia. There it is. And a globe representing the rest of the world. So using your computer or your mobile device, please open up a new browser window or tap and go to the site that is up there on the screen, and we will see where everybody is coming from when you drop an anonymous pin on the map. Show us your location. We'll give everybody's pretty technically efficient. We'll give it another minute to people to populate that screen. Looks like we're dominated in the southern part of the province, but a couple outside of BC, which is great. Right. Oh, we lost somebody from outside the province. All right. Well, it looks like there's not a whole lot of green icons popping back up. So thank you very much for that. It's great to see that we've got a spread across from the from west to east on the south part, and the odd person coming from other areas of the province. There may be people still joining us. So now it's my pleasure to introduce today's speaker, Deborah Curran. Deborah is a professor at the University of Victoria in the Faculty of Law and School of Environmental Studies, and the executive director with the Environmental Law Center at UVic. For over 20 years, she's worked with local governments and community organizations on creating sustainable communities through the implementation of green bylaws. And Deborah is the author of the Green Bylaws Toolkit, and she co-founded Smart Growth B.C. So thank you very much, Deborah, and welcome.
Thanks so much, Michael. Can you hear me okay?
I hear you very well.
All right, wonderful. We will carry on then. It's really my pleasure to chat about green bylaws with you today. And some of you may have seen me present over the last 20 years. And I feel like I repeat myself somewhat because local government jurisdiction for protecting the environment hasn't changed all that much. It just gets sort of different emphases as different local governments come forward in a leadership role and try new things. But really, we have very similar jurisdiction for the last 25 years or so with some small changes. And so it's actually increasingly or even more important now that local governments fully exercise that jurisdiction and take leadership for restoring and improving biodiversity overall. So I'm coming to you today from the traditional territory of the WSÁNEĆ peoples, and I'm very grateful to be here. Normally, you would see my backdrop out my dining room window, which is Pacoles. So it's an important mountain here in Greater Victoria, which is a place of much biodiversity, but also many different international legal agreements between the nations. And so for me, as someone who has a legal background and thinks about bylaws, it's really meaningful to be at a location that has such ecological importance, but also legal importance. The two things are absolutely entwined. And so I approach green bylaws in that sense that it's only because of the ecological that we bring meaning to the bylaws in this kind of conversation. I am going to share my screen and start my PowerPoint that has way too many words on it this time, but because we are by Zoom, it's not as abhorrent as if we were in person. Okay, so really the presentation is around biodiversity, and I'll do a bit of context around Bill 44 at the beginning, a very little bit of context. But ultimately, the things that I'm speaking about and the characterization about connectivity and systems thinking in the way that we do bylaws really comes from and is embedded in the Green Bylaws Toolkit. So I encourage you, if you haven't dug into it, have a look at the third edition and just make sure that you are accessing the third edition. So it is on the Stewardship Center website. And all of these approaches, I guess, have been developed over many years, primarily by local government staff and people working with them, but then have been compiled by a number of us in this toolkit over time. So today I'm going to talk about biodiversity in the context of local government bylaws and Bill 44. So Bill 44 essentially mandating the ability to build 3 or 4 units on any single family piece of property. But I would like to contextualize that, the factors, those 3 things coming together in the context of Indigenous authority, and then go into, in the latter part of the conversation, really the approaches or ways of thinking about green bylaws that help us to make sense. So I often get asked, how should we use environmental development permit areas? And I think that that's an important question at the end of a much longer conversation about how is it that we restore or maintain ecological integrity or biodiversity across our landscape, of the local government landscape or the watershed in which we're working or in which we're living. So while tools are important, local government tools, they don't lead. What leads are the broader objectives and purposes about ecosystem connectivity or biodiversity health, and then the tools fall out of that. And we will really see that in this presentation as I'm referring to ecological principles to try and pull bylaws together to respond to that. And then finally, I'll just provide a few comments about the public commitment to biodiversity or a need for that, in that it's not rules or regulations or plans that are going to preserve biodiversity. It's really going to be a collective sense of quality of life and the importance of ecological health. So in terms of context, what do we mean by biodiversity? I often refer more broadly to what do we mean by green infrastructure, because that's sort of the locations in which biodiversity can occur or is occurring in more urbanized or built settings. So it really is all of those landscapes, those waterways, the water, the ecological function that brings diversity of life and ecological systems. So how one chooses to characterize biodiversity in any specific location is going to be quite different in, for example, the Okanagan watershed than in the Lower Fraser Valley, for example, which are two entirely different ecosystems. And then linking that then to local government jurisdiction. So we think about biodiversity and ecological systems, and then we say, okay, well, what can local government jurisdiction do for that? And this chart, which is in the Green Bylaws Toolkit, is a summary of sort of all of the ways that local governments can protect the environment. And this has not changed very much since I have been working in this area, which is since I became a lawyer a very long time ago and my hair was not gray. So the important thing to point out here is that there are lots of different ways that local governments can attend to environmental protection or biodiversity on private land and on their own lands. But I have never met a local government that is using these tools to their full extent. So because we have largely a discretionary approach, I guess, to protecting the environment from a local government perspective, there hasn't ever been a local government that fully engages these tools in a comprehensive and sort of nested in systems way that one could say that they really are going fully to the end of what they're able to do, and then they're prevented from doing more environmental protection. So there's lots to do. There's lots out there. It's much more of a political issue than sort of a legal issue or green bylaws issue in terms of the protection that can occur. And then finally, in terms of context, I will lead off with Bill 44, which over the last year has caused a lot of concern around biodiversity and environmental protection in the province. And so I am by no means an expert, but I have read the legislation and I have spoken with a number of planning and development professionals across the province about what this means to them in their role working within local government. And so just the Coles notes are very much that in a suite of amendments to the Local Government Act, Bill 44 enables 3 to 4 units of small-scale multi-unit housing, or SMUs, in most single-family zones within urban containment boundaries or in communities over 5,000 people. So with one flick of the pen, the province has essentially rezoned all of, or required local governments to rezone all single family properties to enable small-scale housing. The only other time that I can think of the province being as directive as this, so normally they don't like to take on local governments too much in sort of in a conflict, is twofold. The first was when the Streamside Protection Regulation came in the late 1990s, which we now know is the Riparian Areas Protection Regulation. So that was a couple of years of consultation with local governments, a lot of conflict between the province and local governments, and then finally we got some process by which if you're building near or adjacent to a fish-bearing stream, you have to do some kind of additional assessment. The second time and only other time is when the provincial government imposed the requirement to establish targets and actions related to greenhouse gas emissions in official community plans. So this is I wouldn't say unprecedented, but it's a pretty unique and very direct, some would say blowing apart of sort of single family dwelling zoning and land use across British Columbia. So as we know, the intent is to increase affordable housing, and it directs density into in large part into already existing built areas, which from a biodiversity protection perspective is a good thing. So from a smart growth and a biodiversity protection, you're trying to densify in already serviced areas, and there are exceptions to this. So I'll get to that in a sec. But so you're trying to densify in already built areas and filling in lawns and other places that are low biodiversity, and then protecting more intact landscapes in larger properties and in outside of urban containment boundaries where they are. The challenge has been that the messaging was that as of right, you got to build 3 or 4 units on your single detached property. And there didn't overtly appear to be any consideration of ecological impact of this particular move. And so the perception is, and the messaging is that there's nothing you can do about stopping well, there's certainly nothing you can do about stopping, but there's nothing you can do about regulating or attending to the ecological impacts of these small-scale multi-unit housing infill. That's simply untrue, however. And so, the legislation, so the law itself and the policy manual are very clear that local governments can continue to direct development away from areas of ecological significance and require mitigation or compensation for any impacts, but can't have environmental protections that stymie or don't allow the purpose or intent of the legislation to happen. So this, however, is no different than we've always had in relating to green bylaws and environmental protection. Tree bylaws, for example, could not affect density or the ability to build out at the end of the day. Likewise, environmental development permit areas. So a lot of the tools that we have around green bylaws are not allowed to affect use or density anyway. And this is the same with the small scale multi-unit housing in Bill 44, that ultimately they aren't able to prevent or prohibit development, but they can still certainly regulate, and you can still achieve your ecological goals by using green bylaws, even with the ability to build these new housing units. So part of the problem is public perception that there's no regulation, that there's a ability to develop as of right, but that it then falls upon local governments to point out, well, actually their jurisdiction has not changed. And it's simply the only thing that talks about the impact or underscores what all other bylaws can do is section 457.1, which says that the designation of DPAs and any other kinds of bylaws must not be exercised in a manner that unreasonably prohibits or restricts the use or density of use. And I would say that this statement is no different than what we have understood about local government jurisdiction and green bylaws for the last many, many years. So the question then becomes, if we're in a different place, We now have Bill 44. We now have these small units being able to be built. What is it that we need to do? So we can still use all the tools within the local government jurisdiction to achieve as many objectives on each site as possible. And it certainly doesn't prevent council and staff from doing everything that they had before. And by allowing a flexible approach to small unit housing, developers can better assess the site and decide how and where that development can go within the nested direction provided by plans, policies, and bylaws of each local government. So there still needs to be that social license. There still needs to be that nested approach to bylaws and plans. It's still zoning. There's still maximum site coverage if local governments want. There's still, maximum impervious surfaces if local governments want. There's still the desire for contiguous space or connectivity if local governments want. But we're just using the tools in a bit of a different way to figure out how to do small unit housing. Okay, another factor that I think actually has sort of equally of importance that doesn't get talked about a lot in a local government context is what is the impact of Indigenous authority and rights on local government jurisdictions. So we do have a case from over a decade ago that says that local governments do not have a duty to consult Indigenous nations when they're making decisions. However, the province of BC has committed to implementing the UN Declaration on the Rights of Indigenous Peoples and has enacted a piece of legislation called the Declaration on the Rights of Indigenous Peoples Act that commits the province to making consistent laws with the UN Declaration. So there are many different articles of the UN Declaration, but a few of them are the ability to have, or the right to have, control over one's territory, have a say in what occurs in one's territory, and also free, prior, and informed consent to activities. Now, if you look into the Interpretation Act, there's some sections in the Interpretation Act that says, a bylaw is a regulation, which is a law. And so if we plug down into that, ultimately, at the end of the day, local government bylaws will be subject to the Declaration on the Rights of Indigenous Peoples Act. At the same time, many local governments are committing to implementing UNDRIP, are developing better relations with the Indigenous peoples on whose territory they operate. And so there's some really interesting new relationships and initiatives that are coming out of that. A couple of them include the City of Victoria's Reconciliation Contribution Fund that they established in 2022. And this fund allows anyone to contribute a voluntary amount to the Songhees Nation and Quepsum Nation for their use and recognition of us all being in their territory. There's also a very interesting and detailed MOU between the District of Saanich and the Wasanich Leadership Council to create collaborative governance processes for plans and infrastructure, as well as replace signage and recognize Indigenous relationships across the municipality. And just last fall, all of the mayors and the chiefs, or most of the mayors and the chiefs in the Okanagan and Similkameen signed a memorandum of agreement to undertake Okanagan-Similkameen watershed planning partnership related to water and what's going on in that watershed. So lots of interesting new arrangements and relationships that acknowledge Indigenous authority and include biodiversity in new ways moving forward. Okay, moving on then to if Bill 44 and the inclusion of small unit housing, or the ability to build small unit housing in backyards, front yards, and on properties in general, doesn't change local government jurisdiction, what are the core pieces then of how it is that we need to create a nested approach to green bylaws that will stand us in good stead over the long term? And I'm going to use a couple of examples today. I could use many different examples. There's lots of great examples across the province, but you'll note they're not exact, they didn't start 2 years ago. good local government examples are 10 years in the making, or they are much more long-term. And so it's important to realize that the support and momentum builds, and then we can report out on them after 5 or 10 years, because as you know, in landscape level talk or biodiversity talk, it takes that long to achieve results and see the benefit of it. So the first principle, I'm going to deal with 3 principles. The first one is connectivity. So that refers to maintaining the unimpeded movement of species and natural processes across a landscape. So in a local government sense, we acknowledge this, or we see it mostly in habitat corridors that knit together fragmented landscapes and create links between different places to conserve biodiversity and foster this connectivity of movement. I think the important thing to note is that this is not just on public lands, but it can be on private land, it can be in parks, it can be on crown land, it can be across agricultural land. So the key is creating that connectivity that has biodiversity benefits and values ultimately. We no longer want just standalone parks because they create islands. We want there to be a connection across watersheds and ecosystems, really. And so local governments should have some sense of connectivity within their maps and within their bylaws. And often that starts with, because it has been mandated by the province in many local government areas, but not all, that would start with riparian areas. So that's obviously a key and obvious connectivity corridor. But it also often flows across working landscapes or endangered landscapes. And even if those are if there are some blockages to actual connectivity from degraded private lands, they can still be included in that connectivity corridor, and there can be language created in plans and bylaws about restoration. So certainly environmental development permit areas, one of the purposes can be for restoration. So if citizens or developers ask, well, why is this property in an environmental development permit area, or why are you creating setbacks in your zoning bylaw from this degraded area? You can say, well, it's part of a larger connectivity corridor, and the purpose is to restore it, and that's a legitimate public outcome and in the public interest. So really, this connectivity has to be identified in maps, in policy language, and also then followed up with programs. So for acquisition of key areas, whether it be through a parkland fund or the restoration of different areas over time. I'll just give you a couple of examples. So the first is the Okanagan Wildlife Corridor that really started in 2015. So it's, the initiative is 10 years old, where researchers from UBC Okanagan and the Regional District of Central Okanagan and Okanagan Collaborative Conservation Program did some mapping about what a cross valley or a linear corridor would look like in the Okanagan, recognizing the significant urban development in that place. So there was an advisory committee which included the Okanagan Nation Alliance, the Westbank First Nation, and identified 65 kilometers of a 1 kilometer wide corridor between Okanagan Mountain Provincial Park and Kalamalka Lake Provincial Park to be prioritized for protection. So in terms of implementation, the District of Lake Country designated 16 kilometers of wildlife corridor under its environmental development permit area in its 2018 OCP. And the city of Kelowna followed this lead as it released its draft OCP in 2021 that included an Okanagan Mountain to Kalamalka Lake Provincial Park ecosystem connectivity corridor, as well as a secondary Knox Mountain Ridge ecosystem connectivity corridor. And so these are very localized examples of the ability to not only work across a watershed, but across local governments to achieve very significant connectivity across a particular watershed where, in the Okanagan-Mill community, there's about 30% of the endangered species in Canada. So making a very concerted effort to partner across local governments and conservation organizations and Indigenous nations to bring that about. Another example from a small municipality is the village of Cumberland. Their official community plan defines a connectivity area that is most of, you can see in the light green there. Sorry, I'm just looking at the colors. So the wetland is blue, the dark green is forests, et cetera, and then the light green is connectivity area. And so the intent is to acknowledge unbuilt areas that can be used for stewardship, protection, remediation, and enhancement of connectivity for habitat and wildlife areas, and if developed, implement best practices in design. And in 2014, Cumberland designated an environmental protection development permit area over its entire land base to further help establish this connectivity. And one of the key goals of this DPA is restoration. So recognizing this is an area that's been heavily logged in the past, there is a specific guideline for the DPA of restoration. So when new development occurs, there can be permit conditions put on new development that restoration occurs. I also included the map from the one on the right-hand side of your screen, and the blue is the aquifer or groundwater protection area. And so recognizing the sort of dual purposes of not just terrestrial protection, but also what's going on under the ground and other purposes for protection as well that supports the biodiversity. Another example is the Surrey Green Infrastructure Network that many of you are probably familiar with, but it's such an interesting example because the highly developed and rapidly developing city of Surrey, has taken over a decade to put this in place. In 2011, the city completed an ecosystem management study, and then out of that, identified a green infrastructure network for the city, which is an interconnected network of open space, including parks, streams, and other natural areas identified as hubs, sites, and connecting corridors. This incorporates a wide variety of land cover, so not just agricultural areas and riparian areas and parks, but backyards, urban forests. And the core principles are to preserve large core habitat areas, ensure connectivity between habitat areas, and provide a diversity of habitat features. So it is ultimately about 2,700 hectares. And then the city followed this up with a biodiversity conservation strategy, which is a policy framework for biodiversity goals and targets for the city itself. So this is a great example of sort of the network, and the strategy then follows along in then identifying key properties to acquire, to operationalize at the environmental development permit area level. So you can see this nested approach to sort of identifying the corridors, then bringing it into a policy, and then implementing through a variety of different, not just bylaw tools, but also operational approaches through acquisition, parks, and other things like that. So really what we're looking at in terms of connectivity is we need to have, and you'll see this is a theme. I could use this same slide throughout this presentation. It really is important to have, to work at all scales when we are looking to protect biodiversity. We can't just have an environmental development permit area, for example, because it might deal with the site-specific issues, but it doesn't put them in the context of the larger, what is the ultimate ecosystem and biodiversity protection goals that we have overall as a community. This second area of sort of green bylaws approaches that I wanted to touch on is a systems approach. So as you know, both provincial law and green bylaws, they sort of divide the environment into different ecosystem elements. So tree bylaws are here, watercourse protection bylaws are here, stormwater management's over there. So rather than treating ecosystems or biodiversity as systems that interact and need to be treated as a whole. So green bylaws need to focus or try and as much as possible reintegrate ecological systems and focus equally on restoration as conservation. So I think up until now, we've had a large focus on green bylaws of conservation, like keep it. Now we're going to have to start, when we identify our corridors, we're going to have to start looking at achieving restoration goals. And so we then have a nested and interconnected web of plans and bylaws that will that are the ultimate public interest or public purpose is long-term ecological health. And the final thing I wanted to say before I just give you a couple of examples is we really can't engineer our way out of climate change impacts. So we're not going to be able to build big enough pipes for large stormwater events. So we're going to have to start reintegrating ecological processes into watersheds to attenuate water flows and really be thinking in, a nature-based solutions type way. An example that I wanted to give you is the Central Okanagan Regional District's Aquatic Ecosystem Development Permit Guidelines. So following the Riparian Areas Protection Act and regulation, they have chosen to exceed those standards through their environmental assessment process. So they have their own terms of reference for professional reports for planning services, and that includes for the Riparian Areas Protection Regulation process. And so what they require is a 15-meter undisturbed leaf strip across all of their creeks and setback, or a larger setback requirement as per the Riparian Areas Protection Regulation process. And what they find is that developers or landowners, in order to avoid that process and that specific environmental assessment based on those terms of reference that they've put forward, they develop outside of that 15-meter setback typically, and so then they don't even enter into that process at all. So this has always been a feature of the RAPR, is that local governments can exceed it, and there are very few who do that. And when you exceed it, you can then dig into the process more. If you don't exceed it, you have nothing to say, or you're not able to say anything about the quality of the assessment or the qualified environmental professionals' work. Another example of taking a systems approach is Kelowna's Mission Creek Restoration Initiative that has been ongoing for many years. So Okanagan Nation Alliance has done a ton of restoration. There's been a recomplexing, sort of a setback of some of the diking. There has been purchase of properties that will, and then allowing for flooding of those properties. So the idea is to recomplex the Mission Creek so that it attenuates the floods and it restores the ecosystem that's going on in that very highly developed and channelized watershed. And then finally, the City of Maple Ridge's Watercourse Protection Bylaw that has seen the development of over 30 constructed wetlands as part of the large-scale commercial and residential building development. And they're also then trying to work with Metro Vancouver to include those constructed wetlands into sort of a larger connectivity and assessment, I guess, green infrastructure management strategy and considerations of biodiversity in the region. The final quality, I guess, of green bylaws that I wanted to mention is scale. So green bylaws don't just operate at the site-specific scale, nor do they just rest in an official community plan or a regional growth strategy, but they need to operate at all scales, because it's only by virtue of strong policies, policy framework, and good work that's been done at that level, that the application at the site-specific scale, when you're actually trying to get development permit conditions on a development application for a specific property, that they will stick. So if you don't have that integration at all scales, then you will have what happened in the district of Saanich when they they extended their riparian development permit areas to upland to only 2,000 properties, but that after 2 years, that regime was thrown out by council after 800 landowners spoke out against it by pointing out that the mapping went through someone's garden shed or that it was inconsistently applied. Now, we could say a whole lot about that particular process. It's the only example of sort of the pullback of an environmental development permit area in the province. But it was fair to say that the application at the site-specific scale was not supported by an overall Saanich-wide biodiversity strategy or green infrastructure or network or connectivity corridors. And so it was very hard for staff then to make it stick at a site-specific scale. The final thing, and I'm just going to wrap up because it would be good to leave time for questions, is the final thing I want to note is really that what we're getting at is if citizens who live in municipalities value having building out single detached homes across their entire properties, if they value that more than having quality of life that includes an intact natural environment, then we're not going to see the improvements in biodiversity, and we're not going to stem the loss of biodiversity. So really what green bylaws come down to, if they're going to be effective, and if we're going to actually have functioning ecosystems based on local government jurisdiction, we have to cultivate a culture of conservation. So we can't lead with the bylaws. We lead with those conversations, those public conversations about biodiversity and how it has an impact on our quality of life, rather than conversations at a local government scale being typically reactive to proposals for development. And so the question to everyone is, how do we keep at the forefront those really generative and interesting and positive conversations about who are we together? What do we want for the long term? What do we value? How do we get more biodiversity into our built environment? Or how do we maintain our urban growth boundaries so that we have functioning biodiversity outside of it? Rather than, here's a proposal for development. What do we think of it? Or, is it going to completely blow apart what we hope for the long term for our built environment and for our community? The final thing I'll say on this is I want to just really underscore that a principle, or what can be a purpose of an environmental development permit area, is restoration. And so don't be afraid of including that in your guidelines, that restoration is a purpose. And so when you create biodiversity strategies or connectivity corridors or green infrastructure networks, identify those properties that need restoration, and then have those policies and principles there that you can actually see a restoration and a revitalization of biodiversity in a connected way as part of this larger package of green bylaws. So just to conclude then, Bill 44 does not change local government jurisdiction. So it fundamentally changes zoning for single detached dwellings or single detached zoning properties, but we can still achieve the same or similar objectives, and we just need to use them in more creative ways and more thoroughly. So most local governments do not take full advantage of their jurisdiction for green bylaws. So we really have to recall and continue to bring up that the foundation of our healthy communities is connected ecosystems and connected biodiversity. So through that, or with that ultimate objective in mind, we take a nested approach to conservation. So we need the sort of green bylaws and ecological health objectives reflected at all levels, at a regional scale, at a municipal wide scale, and then implemented through bylaws, through policies, through acquisition strategies. And so, of course, those strategies will be, adapted depending on which site you're dealing with. But we really need action at all of those levels in order to stimulate and continue a culture of conservation across our landscapes. The other thing I wanted to mention is that these objectives of biodiversity conservation and connected ecological systems really meet a number of our emerging, very important personal health and safety objectives around wildfire prevention, around clean and potable water and a safe supply of water, and around adapting to climate change. So the more that we can link green bylaws to those particular objectives, the easier it will be to have a conversation, not just development versus environment, but what is the whole package and the connected package to maintaining and preserving our quality of life over the long term. Please do check out the Green Bylaws Toolkit. Thank you for your time, and I'd be happy to answer a couple of questions.
Oh, thank you so much, Deborah. That was excellent. And we do have several questions in the Q&A feature right now, so I will check those out. I sorted them by most upvote, so please, if you have questions or if you want to look at what's in there and upvote them, we'll try to get to as many as we can, and we had a hard stop at one to respect people's time. So the first question we have in here is from Nancy Gothard. She says, can local governments require deeper setbacks from watercourses than the RAPR methodology dictates? We understand from case law in recent years that this is not permitted. We have a 30-meter setback as policy in our OCP and then as an EDP guideline.
I'm squirming because I didn't review I have reviewed the case in the past and I didn't review the most recent case, but my understanding is, so the Riparian Areas Protection Regulation allows local governments to exceed the RAPR. And so if you have a process that exceeds it, you can establish larger setbacks. And so the question in the court wrestles with the ability of local government, typically where I have seen where I see the court wrestling with the RAPR methodology is that local governments haven't set out in their bylaws very clearly that they are exceeding it. And so according to their own bylaws, so the OCP, their own environmental development permit areas, they're able to establish stricter standards. What the court wrestles with is when a local government goes in and messes with the RAPR process itself. So that's provincially dictated. So you have to do that, but through your own bylaws, you can exceed it. And if you haven't exceeded it, you cannot mess around with the provincially mandated RAPR process, but you can in your own bylaws, you can exceed it.
Okay, thank you. Now, it's a little confusing with the questions here, but I think there's another one from Nancy regarding tree bylaws. Section 50 of the Community Charter identifies restrictions on that authority. They may not restrict use density unless compensation is provided by the LG. The question is, can the local government allow cutting, but then require that replacements be made off-site, such as in a tree planting reserve fund that has goals as identified in an urban forest strategy adopted by council?
Yes.
Okay.
That's the easy answer. But I mean, you'll have to figure out bylaw wise how to do that. So you might do that under an environmental development permit area and related to the tree, but you can certainly require all sorts of conditions for different types of permits and then the ultimate outcome for them. So a very typical tree bylaw will require replanting. And if a landowner chooses not to replant, then they, in lieu, there's typically a financial contribution in lieu, and then the local government could either would typically take control of that and replant elsewhere, as opposed to have the actual individual or developer who has the permit go and replant elsewhere. It might be to a nonprofit who then does the planting of the trees, for example.
Okay, thank you. Now, Nancy has one last question. She has the most popular questions, obviously, that keep getting upvoted. She's wondering on enforcement options for contraventions of an EDP other than through the courts.
There are none.
There are none? No.
There are none.
Right.
You have to go to court to enforce an environmental development permit, period. So that makes them awkward. And so then the question becomes, well, what are some other ways that you can do it? So if you want to, there's sort of the ladder of enforcement. You don't start at court. So what is the sort of educational or in staff involvement in going out to properties or in having conversations or being explicit in the permit conditions? Or does the permit require that a registered professional be on site at certain points to sign off on different aspects of the development? So there's lots of different ways that permit conditions can be more complex or written in a way that has checks and balances put into them, so you can't move on to the next stage before you get sign off at an earlier stage of the site disturbance, for example. So there's lots of different things that can happen, but like ultimate enforcement, like to actually mandate that someone restore or force them to do something, is going to be in court.
All right. Thank you. We have a couple of questions from Yvette Crane. The chart of local government jurisdiction that you put up, where can we get a copy to share with local government officials? And is it part of the Green Bylaw Toolkit?
It is, absolutely. Yeah, it's contained in the Green Bylaws Toolkit. So I want to say around page 20, something like sort of in the earlier part of it. And I'm sorry, I don't have the exact page number, but it's in the earlier part of it.
Thank you. And then Yvette asks, regarding Bill 44, and if we want to provide this information to local officials and staff, especially regarding can direct development away from areas of eco-significance, what can we cite to back this up if we present it to them?
It's actually in the policy manual. So like I took that stuff, sort of those points from the provincial policy manual. So have a look, dig into it, search environment, or and there are a few mentions.
Excellent. Thank you. And now we have a couple of questions from Larissa, or a question around UNDRIP, I think. UNDRIP is a minimum international standard. How could you address the jurisdictional complexities of imposed elected band system as the leadership body when they are still operating under Canadian law? For example, local government upholds agricultural frameworks in relation to the zoning. TNRD is currently rezoning the OCP in our areas. How can individuals or communities address the lack of environmental due diligence by organizations in our areas when they are protected by the language of policies that favor the ability to do bare minimum engagement with Indigenous communities?
Yeah, I absolutely agree in that, local governments and relationship with Indigenous nations in terms of whether it be legal or not legal is very awkward. And there isn't really anything in state law that mitigates those colonial impacts of, land turned into private land without consent of Indigenous nations. So I'm not at all suggesting that local governments have significant authority to be able to address sort of these fundamentals of colonial Canada, like the province can, because the province can enter into funding agreements, they can do land back, they can do a number of different things, but local governments don't have that authority as creatures of provincial statute. However, I think that they can use their jurisdiction in much more creative ways that is respectful of Indigenous authority, at least in recognizing that Indigenous nations have governance authority within the territories and creating new forms of collaborative decision-making, collaborative management, for example, of parkland, new uses for public land, so allowing traditional use of land that municipalities have control over. There's a whole bunch of different things, but I agree it does not go to the fundamentals of colonial Canada and changing that framework at all.
All right. Well, it's getting on. We probably only have time for one or two more questions. George Garrig asks, are there maps available that show wildlife corridors and our known game trails?
That's a great question, and I would defer to the ecologists on the call. So I know there are lots of different databases the province has around mapping endangered species and those kinds of things. I'm the Green Bylaws lawyer here, and I don't know that. So you might actually look at the subsequent webinars because they're going to be dealing with the different data sets that the province has about biodiversity.
Excellent. I think Danielle said she's going to try to answer that question as well. And then Matt Robinson, this will have to be our last question. Matt Robinson asks, are the objectives set out in a municipality's developmental permit area, examples given restoration, ecological connectivity, determined solely through local government decisions as directed by community and public support? Or are these objectives in the DPAs determined through existing bylaws to some extent?
That's an interesting question. I'm going to answer, and I might not quite get at it directly. What I'm going to do is just explain the structure of environmental DPAs. So environmental DPAs, the purposes and objectives are set out in the Local Government Act. And so you can only enact an environmental DPA for those purposes, which is protection of the natural environment and ecosystems and biodiversity. So that's very broad. It's not just individual pieces of the environment. It's not just a tree that has a nest in it. It's ecosystems and biodiversity. So they can be cast quite broadly. Then the Local Government Act sets out what an environmental development permit can do. So it can require that land remain free of development. It can require that practices, sort of development practices occur in a certain way. So again, the Local Government Act lists those specific things that a permit can actually do. And so what local governments do is typically within their official community plan, they set out the justification for why this EDPA is being established, and then set out the actual objectives and guidelines about what they expect to occur on the sites that are within that EDPA. And it is from those guidelines that the permit conditions are written. So if the guidelines don't point to biodiversity protection, the permit conditions cannot deal with biodiversity protection.
Great. Well, thank you so much, Danielle. Thanks everybody for their questions. I'm sorry we couldn't get to all of them. But yeah, for Deborah, I'm sorry, Deborah Curran, your excellent presentation. Really thank you so much for your time. Really insightful. I think Ali's going to throw up a slide around the survey as mentioned earlier. We'd greatly appreciate if you could take a few moments to complete it. The link's available in the chat, hopefully. Sorry about the chat as well. There was some technical difficulty there that we were trying to resolve, but I'm not sure. We'll have it resolved for the next seminars for sure. So everybody's able to use the chat function. And again, as we said, more seminars coming up over the next 2 months. So we encourage you to join us on February 11th at noon, where we'll be discussing the next topic, planning for nature and growing communities, up there on the slide. And again, thank you so much for joining us today. I hope you found this webinar informative and engaging. Thanks for sharing your lunch with us. And we look forward to seeing you at our next webinar in the series. Thanks, everybody.